It's in my purse. You want me to go get it? I have a minute, I'll go get it.
Huh?
I have a minute, I'll go get it. It's not down there. See it anywhere?
Ms. Sherman, you may want to mute your microphone.
Okay.
This is the detention docket for the 323rd District Court for Wednesday, February 24th, 2021. Comply with the Texas Supreme Court Emergency Order number 33. We are not conducting in-person proceedings. However, we are using Zoom. And to comply with the open courts provision of the Texas Constitution, we are broadcasting these proceedings on YouTube so the public has meaningful access to what occurs inside a public courtroom. No portion of this broadcast may be copied, recorded, or published. Violations are punishable by contempt of court of up to 6 months in the Terry County Jail and a $500 fine. Also would like to remind everyone this is still a court proceeding, so we are expecting everyone to behave appropriately for court. So that means please do not be moving around. Please be dressed appropriately. Do not be laying down in bed or on a sofa. Please refrain from having bright lights from behind you that will shadow out your face. If you are not an officer of the court, you're expected to have your camera on and be centered on the camera. So that would mean, Brittany, you put your camera on. All right, thank you. All right, so we'll go and start with Mia Hernandez. All right, Mia, I'm Judge Kim. This is a detention hearing. The law says when a child is brought to a facility, you have to see a judge within 2 days. I have to decide whether to keep you here or release you. If I keep you, you will see a judge every 10 days while you're here. You do have a right to remain silent. You have a right to an attorney. We have appointed Mr. Beaver as your attorney. And let's see.
Good morning, Your Honor.
Good morning, Mr. Beaver. Right, so let's see, last week or yesterday about 7:30, there was domestic. Mom told the police she had taken your phone away for discipline. She was sitting in the driver's seat of the car. Evidently, you jumped on her, was sitting on her chest, making it difficult for her to breathe. And you're pinning her back against the steering wheel, causing pain. Went to the house, and evidently you pushed your mom down while trying to get your phone. You're detained and transported here before. You've never been here before, but the family said this has happened. This is just the first time they reported it. Authorities. Do we have a parent here?
Yes, Your Honor.
Oh, hello, Mom. All right, so Mia's 16 years old. Tell me, when did her behavior start escalating to this level?
It's been about a year and a half.
Okay.
Yeah. She started sneaking out of the house at night.
Right.
And then when we brought it to her attention, she continued to do it, and we ended up locking the windows, and she continued to try to sneak out, and we installed sensors inside the house so we could catch her when she was going downstairs, and she was able to sneak anyways. She would crawl around on the floor so the sensor wouldn't see her. And we ended up having to, I had her go to her father's house for a while, since December of last year, till the end of the school year. And she was failing horribly, 30s, 40s, 50s.
Oh, okay.
And yeah, it's just been really bad. And it just escalated from there, stealing her dad's truck in the middle of the night, smoking weed.
Well, let me ask you this. Is there just a general attitude problem? Is she going to do it her way?
I'm sorry?
Is it a general attitude problem that she's going to do it her way and nobody's going to tell her otherwise?
Yeah, she's going to do what she wants to do, and no one's going to tell her. And if I tell her no, it doesn't matter. She's going to.
Okay. No, I understand. And how you said about a year and a half this has been happening?
Yeah, about a year and a half now.
All right. So, Mom, this is what I'm going to do with Mia. Right, Mia, I'm going to go ahead and detain you at this point. All right. You're not doing well in school, so we're going to make sure that you get enrolled here at our campus, and we're going to monitor your behavior level. When you get to level 1 outstanding and you hold it for 3 days, at that point, I'm open to the idea of releasing you. You will be on, if I release you, you'll be on electronic monitor as well. Mom, are you worried about any other drugs other than marijuana?
That's the only thing I've been able to find is marijuana and vapes.
Okay. Do you want us to give her a drug test?
Sure. Yeah.
Okay. So Mia, we're gonna go ahead and get a hair follicle test for you. And so that will go back the last 6 months of any drugs you've been using. That way your mom knows. Also, Mom, before I release her to you, I'm going to require you to get one of those door alarms that you have on her bedroom door. So when her door shuts at night, if she opens it, the alarm goes off. So she will be stuck in her room overnight. And so I'm not going to release her to you because it just seems like she's determined to find a way to sneak out and do her own thing. Yeah. And so if that's the life she insists on, then this is the consequence. So you can get them at Walmart or online on Amazon, but they're just little alarms that you set up and you arm and disarm from the outside. And that way, if she opens her door, it wakes up the whole house. Okay?
Okay.
All right. So, Mom, we'll see if she gets her behavior level and gets her attitude right, then we'll give her a chance to go home and see if we can set her in the right direction. If she doesn't, then she'll just stay here for a while. Okay? All right. Thank you, Mom. Thank you, Mia. Breeland Jordan. All right, Ms. Wade, I'm going to ask you, just please try and not have the camera move while you're here. It's distracting for everyone else that's on Zoom. Thank you. All right, Breeland, I'm Judge Kim. This is a 10-day detention hearing. You've been here for 10 days. I'm deciding whether to keep you here or release you. If I keep you, you will see a judge every 10 days while you're here. And so you were arrested. This is where the car in the hotel parking lot, you left and you came back. And then yeah, this is where you refused to be truthful about the father of your baby. And all right, well, Breeland, she's still not giving up the name of the father of the baby, correct?
I did give the name. They came back. They said they came back and told.
I'm not talking to you. Mr. Nava?
Yes, sir.
Did she give up the name of the father of the baby?
If I recall, she did not give me the name, but she did give me the age.
Did he give you a what?
She gave me the age, but I don't remember if she gave me the whole name.
Okay. All right. Well, we have a parent. Okay.
Grandma there.
Grandma. The mom was kicked out of Zoom last time, right? For misbehaving.
That was 2 hearings ago. Yes, and she was kicked out of the Zoom hearing.
Well, Breeland, decisions have consequences. So if you're still refusing to tell us the name, and you're also level 2, so you know I'm not going to release you. So start making good decisions. Help yourself. Make your situation better. Stop making it worse.
Judge,
Go ahead and continue. Thank you, Breeland. Terrence Price. Okay, she can sit down. Bring her back.
Yeah, I want to tell.
Breeland, I just got done telling you to sit up. I just got done telling you to make your situation better, not worse. And you go and you kick that chair back and you storm out of there like a baby. Quit it. Make your situation better. If you think you're controlling the situation by acting like a child, you're not. You are. You are controlling it. You're going to stay here. And you're going to get placed. You're going to have a commitment. You're going to have all kinds of issues. So either wake up one day and say, I'm going to make my situation better, or I'm going to cry and make it worse. Stop making it worse. Every single time I see you, you make your situation worse. If anything, make the job easier for your attorney. Stop making your attorney's job harder. Figure it out. Life isn't here. This isn't your world that we all sit here catering to you, thinking about poor Breeland. We're thinking about how you're here making bad decisions and making everything harder on yourself. Just grow up. Thank you, Breeland. Terence Price Tucker. All right, Mr. Tucker, I'm Judge Kim. This is a detention hearing. I'm making a decision whether to keep you in custody. I'm sorry. When a kid's brought in, you have to see a judge within 2 days. I have to decide whether to keep you in custody or to release you. If I keep you here, you have to see a judge every 10 days while you're here. You have the right to remain silent. You have a right to an attorney. If you cannot afford an attorney, we'll provide one for you. Mr. Youngblood has been appointed as your attorney. Good morning, Mr. Youngblood.
Good morning, Judge.
All right. So, see, Terrence, well, wow, let's look at this. You're 14 years old. July of last year, placed on probation for evading in a motor vehicle. You were brought in originally when you were 13 years old for evading arrest on foot. So you had some problems on probation. Well, let me ask this. Mr. Howard, what were the violations of probation back in June of last or July of last year?
It was the same thing, Your Honor. It was a UUMB. The same.
Okay, so he picked up a new offense.
Yes.
All right. And
He was
then,
adjudicated on that offense on January the 5th. And again, he repeated the same offense again, allegedly, currently right now.
right. So he evidently took a car, got in a car chase with the police, got probation for that. Then in November, took another car and then ran this time on foot. So that probation was rolled in.
Mm-hmm.
And then, so now February 24th, you were referred in custody for unauthorized use of motor vehicle. And when they tried to pull you over, you got out and began to run again. So they deployed a dog and you were bit by the dog and detained. So I guess you're fast, just not faster than a dog. All right, well, Terrence, I'm absolutely convinced that if I let you go, that you would take another car and go and run from the police again. So this one, Mr. Howard, correct me if I'm wrong, but this is the third UMV within a year. Does that sound about right?
Yes, Your Honor. I actually I also was going to ask you if I would request a psychological, if possible.
So I think that's a great idea. So I'm going to go and order a psychological evaluation. Let us know when that comes in, because I probably want to set this on a motion to modify probation pretty quickly.
You got it.
I just don't think that we can do anything to help this child in the community anymore. It's made pretty obvious he doesn't want our help. All right. Thank you, Mr. Howard.
Thank you, sir.
May I be excused, Your Honor?
Yes. Thank you, Mr. Youngblood. Have a good day.
Yes, sir.
Micaiah Walden.
And I'll be sitting in for Shaquita Burrell there, Your Honor.
All right. Thank you, Mr. Drummond. Mr. Walden?
Yes, sir.
Okay, Ms. Walden. I'm Judge Kim. This is a detention hearing. When a kid's brought in, you have to see a judge within 2 days. I have to decide whether to keep you here, release you. If I keep you here, you have to see a judge every 10 days while you're here. You do have a right to remain silent. You have a right to an attorney. We have appointed Ms. Mills as your attorney. Is Amy Mills here? I see in the waiting room Amy's iPhone, but is that, I don't know if that's Amy Mills or not. Let's see. All right, Ms. Mills. Can you hear me, Ms. Mills? Okay. I think you're on mute. I saw you in the waiting room, but I didn't know Amy's iPhone. I didn't know if it was you or a parent, so I took a chance. If you don't mind, change your name to, like, you know, attorney or something, or Amy Mills. That way I can let you in next time at the beginning. I think you're still on mute as well.
I think I'm off now.
Okay, thank you. Good to see you.
Okay, you too.
All right, so Ms. Walden. Well, started when you're 14 with an assault of public servant, which you got probation for January last year. While your case was pending, you picked up a criminal trespass. 10 days after you were placed on probation, you were arrested for theft of property, probably a car. Then 3 months later, you're still on probation, you get arrested for unauthorized use of a motor vehicle, which then you were placed on probation again. A month after you're arrested for unauthorized use of a motor vehicle, you got arrested for assault causing bodily injury. Then after you're on probation for the assault public servant and unauthorized use of a motor vehicle, you get arrested for, oh no, you have some probation violations. All right, so now we issued a warrant for you on February 9th because you removed your electronic monitor and left home without permission. So we brought you in, you turned yourself into detention staff. We placed you at Lake Granbury and you were unsuccessfully discharged. September last year, you went to Lake Granbury again. In October, you turned yourself in. After you left house, you're home without permission. So in January of this year, you were supposed to get placed at Rockdale Academy, and your probation was extended, but it looked like there was no bed available until April of this year. So Judge Porter allowed you to go out on electronic monitor until a bed was available, and you removed the EM. All right, so, well, Ms. Walden, it seems like Judge Porter gave you a chance to wait at home instead of waiting here for a bed to open at Rockdale, but it looks like we don't have a parent here, do we, Ms. Walden?
Oh, we do. She's right there.
Who's right there? Who's the
I'm right here, Your Honor.
Okay, thank you. All right, well, Mom, it looks like we gave her the chance to wait out the placement at home, but she's going to refuse to do so. And so I think we're just going to have to keep her until a spot opens up at Rockdale. All right? All right,
I agree.
Thank you, Mom. We appreciate your help. Yes,
The
Mr.
PO is
Drummond.
not planning. Yes, the PO is not planning on following that technical on the EM
Okay.
since she's going to be detained waiting on that.
I agree with that, especially because she has a placement ready. And so
Yes.
I don't really expect her behavior to change too much. I was just hoping she could control herself enough to wait out the bed. But if she
Yes,
can't, then she can't. Thank you, Mr. Drummond.
Thank you, Your Honor.
All right,
Thank you.
All right, Mr. Harris.
Yes, sir.
Oh, okay, at this point, I'm going to turn the docket over to Judge Porter, and I'll return for the remainder of the under 14-year-olds.
Thank you, Judge Kim.
Thank you,
All
Judge
right.
Porter.
Good morning, Mr. Harris. How are you doing?
Good, sir.
All right. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days. Thereafter, this is your 10-day detention hearing. You have the right to remain silent. You also have the right to an attorney. Your attorney, Mr. Berger, is here. Hi, Mom. Good to see you again.
Hi, how you doing?
I'm okay. Didn't want to see you again under these circumstances. We tried. We put him on probation back in January. Mr. Berger, he's been level 1-0 since the 11th of this month. But do you know if we've had the psychological evaluation completed?
I have not received one yet, Judge.
All right. And Mom, have you been able to get in contact with MHMR yet?
He is still on the waiting list for that as well, right
Okay.
now that we know of.
So the court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention, Mr. Harris, for the offense of assaulting a family member, which is usually, those are usually your victims. Mom, what are your thoughts?
I'm actually the victim in both cases, sir. And we discussed things last night, and right now, I think it's best that he's either detained or put into placement.
Okay.
I love my son, but I really think that's the best right now.
And I remember at our hearing first part of January. Mr. Berger, what are your thoughts?
Judge, I really don't know what to add to that. I mean, Mom is the victim. She's the one that has to deal with the consequences of him coming home. I will say that in speaking to Anthony, he appears to be truly remorseful and might be able to get his act together, but I think it's too soon to tell.
All right. Mr. Harris, today I'm going to order that you be detained, but here's a couple of things. You've been level 1-0 for nearly 2 weeks. You want to maintain that level 1-0 because that puts your attorney in the best possible position to argue the best possible outcome for your new case as well as your old case, because you're still on the hook for that old case with me. But if you maintain level 1-0 in the back, that goes a long way with me in considering what I should do with your old case. All right. So you want to do that to help yourself. Does that make sense? All right. Between now and then, I want you to continue talking with your mom, continue trying to repair that relationship. Okay. Now I see your hands raised. Do you want to ask me a question or do you want to tell me something?
It's not about my case, nothing. It's about, oh, yes, sir.
Is it a question?
Yes, sir.
Okay, what is your question?
It's about the rehab facility my mom was talking about last night with me on the phone. She said she talked to my PO when they was talking about some drug rehab facility, and when she told me I wasn't in good spirits about it, but now that I had some time to talk with friends and just, they made me realize maybe I need to stop being selfish, and that's the best option.
Okay, I want you to talk about that with your attorney. I want you to talk about that with your probation officer, and I want you to talk about that with your mom, okay? Because your PO, your lawyer, and your mom can all get together and work together on that issue to help you, okay?
Yes, sir.
But it's going to be up to you to convince all three of those people that you're willing to commit to that, okay?
Yes, sir.
All right. Will you do that for me?
Yes, sir.
All right. I got to order that you be detained, but keep maintaining your level 1-0 in the back and keep working on your mom, working on that relationship, rebuild those bridges. All right. Thank you, sir.
Thank you. Thank you.
Thank you, Mr. Berger. Nathan Knox. Good morning, Ms. Sherman. How are you?
Good, thank you.
There we go. Now we got some overhead light. All right. Morning, Mr. Knox. How are you?
Pretty good.
Mr. Knox, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Sherman, is here. Now, I'll note that you've been level 1-0 since February 11th. The court previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. Ms. Sherman, do we, or Mr. Kroll, do we know if all of the firearms have been recovered yet?
Your Honor, I was going through that this morning, and he had a new offense coming yesterday afternoon for evading arrest with the vehicle. I informed him about that. When that came in, I got 175 pages of supplemental reports today that I've been trying to dig through to see if all the firearms have been recovered.
Can
And
you shed
I'm
any
not
light on that,
clear.
Ms. Sherman?
I have no other information besides that.
Okay. That's a real concern because, you know, if a Glock pistol is out hiding under a bush and I let Mr. Knox go, he might get that pistol and go after somebody, or worse, a 4-year-old kid could reach under that bush and find that Glock pistol and think it's a toy. So it's real important that we find out where those weapons are. Ms. Sherman, maybe you can help alleviate the court's concerns regarding that and between now and the next time we meet.
I'll speak with him, Your Honor.
Okay. You know, Mr. Knox, right now, I'm just too scared that if I were to release you, that without knowing where those guns are before you're gone, I don't know what, I'm afraid something bad would happen. I'm glad you're level 1-0, but you can help yourself out by helping your attorney on this issue, all right? As for today, I'm going to order that you be detained. Thank you, sir. All right, Tygon Nesbit. Thank you, Ms. Sherman. You'll be back in just a little bit, I think. Yep. All right. Good morning, Mr. Nesbit. How are you?
Good morning. Good morning.
My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Hall, is here. Do you see him on the screen?
No, sir.
Ray, can you say something?
I'm right here. Can you see me?
Yes, sir.
All right. The court's previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. I will note that Judge Terry placed you on DPP last November for a UCW and a failure to identify. You got to level 1-0 in the back on the 12th, but you've since fallen to level 2 outstanding. Mr. Hall, do we know where Dad's Smith & Wesson is?
Judge, my client thought that they had found it, but I talked to the mom a few minutes ago and she said that they haven't, that he misunderstood what the dad was saying. All this stuff happened before he was put on the DPP. So
Okay.
mom's requesting that he be, released, that he had done better since, that time period and on DPP. So we'd ask that he be released on the monitor.
Is that Dad in the family room?
Your Honor, that is biological father. The incident happened with his stepfather.
Okay. Well, he's level 2-0 today, Mr. Hall.
Yeah.
And so I can't release him. He's got to be able to demonstrate he can maintain level 1-0 in the back, and that's the threshold issue before I can consider his release. The next question that's going to pop out of my mouth after he gets there is, where's that Smith & Wesson?
Right.
And, until we know where that Smith & Wesson is, it's just, I'd feel better knowing that stepdad had that Smith & Wesson back, or we knew where it was, so that it doesn't get in the wrong hands. Okay.
Absolutely.
All right. Now, Mr. Nesbit, I see your hand raised. Your attorney doesn't want you to say anything, but I don't think Mr. Hall would mind if you had a question you want to ask me. So do you wish to ask me a question?
Yes, sir.
What is your question?
My question is, how do I say this?
Okay, let me stop you right there. If you don't know what exactly how you want to say it, what you need to do is talk to your attorney about it first. And that way he can help you formulate that question, because there's a prosecutor listening in on this, and anything you say might give him ammunition to use against you. You don't want to help the prosecutor, do you?
No, sir, but.
Okay, well, maybe if you talk it over with Mr. Hall first, Mr. Hall can help you formulate the question in the right way. Does that make sense? All right. So let's hold off on asking that question today. Talk to Mr. Hall about it, and then he can help you with that, okay? All right. As for today, I'm going to order that you be detained, all right? Thank you, sir.
Thanks, Judge.
All right. Elton Olive.
All right, let me get on things, sir.
Mr. Youngblood already leave. Looks like he did. Mr. Berger, do you mind helping out on this?
Sure, Judge.
Thank you. All right, Mr. Olive, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Mr. Youngblood, your attorney, couldn't be here today, so I've asked Mr. Berger to step in and help you out on this hearing. He's the guy, glasses, and he's got that, looks like a sandwich board. He's waving his hand behind him. See that?
Yes, sir.
All right. So we're scheduled on the 12th of January for an out-of-custody detention hearing due to continuous and multiple violations for terms and conditions and non-compliance with substance abuse treatment recommendations. You've got currently on probation for several things, including several things that got taken into consideration with the case. Mom is also advising your probation officer that you'd stolen money from her, but that she did not make a police report. So do we have a family member here today?
Yes, sir.
Ms. Wade, how are you?
Excellent. How are you, sir?
Oh, better than I deserve. All right. Give me just a second.
Your Honor, may I add that I just received a notification that a motion to modify has been set for March 10th as well?
Yes, ma'am. The court is aware of that, and that's in front of Judge Terry.
Okay.
So, Mom, he only got to level 1 outstanding today. And previously, Judge Kim told him that if he could get to level 1.0 and maintain it for 4 days, he would consider, but not necessarily grant his release, but at least consider it. So he fell off the wagon a little bit. He just got back to level 1.0, and he hasn't yet held it the time that Judge Kim was requiring. What are your thoughts, Mom?
I have not spoke to my son since before his second 10-day hearing, or his first 10-day hearing after he was initially detained. He chooses to call my mom because of the conversation that we had the last time we were on the phone. He told me he was level 1 outstanding, and I just simply asked him if he was going to continue that behavior when he came home. And he said I was being negative, putting him down. He didn't like what I had told him, so he does not contact me anymore. The last that I have heard was from a detention officer saying that he was in an altercation with another child in the facility, and that he was making allegations against the officer that had to restrain him because of that fight he was involved in. So that's the last that I have heard from the detention center, as my son does not call me.
Okay. It sounds like you're not yet convinced that if I were to release him, he would maintain level 1.0 at home for you. Is that correct?
Like I said, I haven't had no contact with him. He chooses not to call me because he didn't like, what I had told him on the phone, being real with him. He chooses to call my mom and not me. So I haven't had, I haven't been able to speak with him, to know his feelings, to know anything that's going on with him. I know that they're still currently looking for a behavior placement for him. And then he does have that motion to modify, but like I said, I haven't spoke to my son since right before his first 10-day hearing.
So what I hear you say is you haven't spoken to him in quite some time. Is that correct?
Yes, sir.
And then second, because you haven't spoken to him, as you just told me, you're not yet convinced that he'll behave if I let him come home. Is that correct?
Exactly, because I don't.
All
I do.
right. Then Mr. Olive, because we're not yet convinced that you'll maintain level 1.0 as you go home, you haven't yet demonstrated consistency of your behavior in the back, I'm going to order that you be detained. Thank you, sir.
Thank you, Your Honor.
Felicity Willingham. All right, Mr. Berger, I think I'm going to ask you to step in again.
Can do.
All right. Are you Ms. Willingham?
Yes, sir.
Ms. Willingham, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Violet Nwoke, could not be here today. So I've asked Mr. Berger to step in for Violet. Is that okay?
Yes, sir.
All right. Now, I will note that the court previously found probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. And I'll also note that you're level 3A this morning. You did get down to, or get to level 1 outstanding for a brief moment, but then you fell back again. So let me encourage you to get back to that level 1 outstanding for me. Can you do that?
Yes, sir.
What do you think you need to do to get back to level 1 outstanding?
Follow the rules and just stay to myself like I've been doing.
And also, are you on a do not associate with somebody?
Yes.
Yeah, see, Judge Porter finds out these things. Now, when you're on a do not associate with somebody, are you supposed to have notes about that person in your room?
No.
Okay, so that's one thing we can stop doing, right?
Yes, sir.
Second thing, you mentioned follow the rules. What's the hardest rule for you to follow in the back?
It's my mouth.
So before we open our mouth, let's think if it's something about whether it's something we really have to say right now. Okay? And let's don't talk out of turn. So work on that and work on following the do not associate for me, will you?
Yes, sir.
Okay. But what are Judge Kim's rules? What does Judge Kim require you to be at before I can consider your release? What level?
Level 1.
Uh-huh. So what do I have to do today?
You gonna detain me?
I have to, don't I?
Yeah.
Okay. So between now and the next time we see each other, what are you going to do?
Follow the rules and do not associate with the person who I'm on DNA with.
There we go. Because when you associate with that person, you end up in trouble, right?
Yes.
All right. Thank you, ma'am. That'll be the order of the court.
Thank you, Your Honor.
Thank you, Ms. Castillo. All right, Ashlynn Wyatt. Good morning, Ms. Wyatt. How are you?
Good, how are you?
Better than I deserve. Ms. Wyatt, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Sherman, is here. Do you see her on the screen? Harmony, go ahead and say something.
Hi, Ashlynn.
Hi.
Do you see her now?
Yes, sir.
All right. I'll note that you've been level 1.0 since the 11th of this month. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. Ms. Sherman, do you know if the psychological has been completed yet?
I haven't received a copy of it, Your Honor.
Mr. Lewis?
It is not, Your Honor.
Okay, when's it scheduled?
I'm not clear on the scheduling. It was requested. I haven't gotten any confirmation from psychological services that it's been scheduled, but I've verbally been told that it has. I believe the psychiatric evaluation, which was also ordered, may have been conducted this morning if they could squeeze her in. But the psychological, I believe, is still pending, probably in March.
Ashlynn, did you see the doctor this morning?
Sure.
Okay. You don't want to say any more than that. Okay. And has the nail bed test been completed?
No, sir.
Okay. And I realize it couldn't be completed last week like we were planning on. Do we have any idea when the nail bed test might be completed?
I've left voicemails with our contractor and have not heard back.
Okay. Ms. Sherman, does she have a family member?
Ms. Barr is here. That is mother.
Okay. So let me hear from Ms. Sherman first. What are your thoughts?
Well, Your Honor, my thoughts are she has been level 1-0 for almost 2 weeks, and through no fault of her own, we haven't been able to complete the psychological and psychiatric and the nail bed test. I feel like if she is released, we can get those appointments done out of custody. And she's been working really hard, so I feel like it's kind of unfair to keep her there.
Okay. Mom, what are your thoughts?
Your Honor, forgive me if I start crying. I've spoken to her just about every day since she's been detained. She does seem remorseful. I am a little fearful that her behavior is not going to change long term. I feel like when she comes home, she'll behave for a little while. But I'm terrified that she will revert back to her, the behavior that got her here. I think she needs to understand, and I hope that she does, the gravity of the situation and the poor decisions that she's making and other kids that she's associated with. She's putting her life and her future at risk, and she's subjecting her 8-year-old sister to this behavior. She's putting both her sister and I at risk as well. We received a notification from the apartment complex within days of her being detained, saying that they could term our lease early because of the marijuana coming from the apartment, the arguing, the fighting, the loud music, so on and so forth. So, you know, I'm glad that I got to hear from her attorney because I did want to hear from her attorney. Those are my concerns. I mean, yes, we miss her, we want her home, but I've also got to make sure that my 8-year-old, Ashlynn, needs to understand the gravity of the situation.
As for today, and I'm really going to put a lot of burden on your shoulders, Mom, because you know your daughter better than anybody else on the screen. If I were to release her today, do you think that your daughter would be a danger to herself, a danger to you, or a danger to your 8-year-old daughter if I released her?
I don't think she would be a danger to myself or my daughter. I did get a call from the doctor that conducted, I guess, the psych eval this morning. The call literally came in right before this Zoom meeting started. So I've got a voicemail. I know they want to put her on medications. As long as we can get that rolling, then I think it would be okay. But she needs to know I will not hesitate to do what I need to do going forward.
All right. Mr. Lewis, do you have anything that you can add?
No, sir. I can point out that she might be appropriate for electronic monitor. And also my view that mother, if there are any problems, will call me. I have every confidence that if there's any misbehavior, mother will immediately notify me, and if it's an emergency situation, notify the police. And all of the appointments that haven't been done can be done out of custody if Ashlynn will cooperate.
If I may, Your Honor, Mr. Lewis and I had also initially talked about a sweat patch that I think because of the drugs that we have found in the apartment. So it's not just the accusation of the smell from the neighbors. We have found them ourselves. I think the sweat patch would be a good idea.
Your Honor, may I add one point of clarity regarding the psychological?
Yes, sir.
It appears that she saw Dr. D, the psychiatrist, this morning. It was not the psychological. That's scheduled for next Wednesday, so a week from today.
All right. Ashlynn, you've been level 1-0 for almost 2 weeks. The psychiatric has been completed, and your mom's right. The sweat patch is appropriate. I'm going to authorize your release on the electronic monitor. You'll also be hooked up with a sweat patch. If you tamper with the monitor, if you tamper with the sweat patch, I can all but promise you I will consider those violations of your release. You'll be right back in detention. Also, you're to go to school as a condition of your release. No skipping classes. If you skip one class, Mr. Lewis will find out and tell me. You're likely to come right back to detention. And then you'll have to maintain level 1-0 for 30 days before I will consider your release. So when you want to hit a marijuana cigarette, when you want to skip just one class, you need to stop and ask yourself, is it worth coming back to detention for more than 30 days just for one hit of marijuana or skipping one class? Because those are the potential consequences. Do you understand that? All right.
May I weigh in real quick, Your Honor?
Yes, sir.
My understanding from others, Ashlynn attends school online at this point, although there's been some discussion of maybe upgrading her to on campus. And I also understand that there has been some issues with her logging in. Just so the court clarifies that failure to log in to online school is the same as skipping class where she were in person.
It certainly is. You don't log in, or if you black out your screen instead of being visibly on camera for your teacher, I consider that skipping class too. All right?
Yes, Your Honor, she missed the deadline for the next 6 weeks, so she will have to continue doing online as opposed to in person.
Okay. As long as she knows the consequences of, not logging in and blacking out her screen so that nobody knows whether she's there or not. All right. That'll be the order of the court. I'm going to turn things back over to Judge Kim.
Thank you, Your Honor.
All right, thank you, Judge Porter. So next we'll have Ladarium Bailey.
Yes, sir.
All right, Mr. Bailey, I'm Judge Kim. This is a detention hearing. The purpose of this hearing is when a child's brought to a facility, you have to see a judge within 2 days, have to decide whether to let you go or to keep you here. By keep you here, the law says you have to see a judge every 10 days while you're here. You do have a right to remain silent. You have a right to an attorney. We have appointed Ms. Jacobson as your attorney. Good morning, Julie.
Good morning, Judge Kim.
All right, so Darian, let's see. Oh, now we're looking at this. I forgot. So these proceedings have been broadcast on YouTube for the public to have meaningful access, but in compliance with Chapter 5408 of the Texas Family Code, we are children under 14 are considered. The hearing should be presumed to be closed to the public when this court can find the interests of the public or the interests of the child are better served by making the public accessible. So at this point, I'm going to discontinue the live stream of this hearing. Please give 20 seconds for the tape delay.